From the steps of the California Capitol, Lawyer Monthly presents James Daniel Peters III, the man who decided to sue the California governor and all 977 school districts on behalf of 800,000 special education students. The governor has already settled his part of the case.
Hi, my name is James D. Peters III. I'm the executive director of one of the top special education law firms in California. I've testified before Congress regarding special education matters. I also have a son with the diagnosis of autism. And yes, it's true. I'm the one who sued the governor of California and all 977 school districts in California because they violated federal and state law regarding our kids, all 800,000 of them that were sent home without the proper services they required, such as speech and language, occupational therapy, mental health, behavioral services, and even specific learning disabilities. One of the things that I'm going to talk about today is what happens now when everybody's going back to school. I mean, here in the States, Europe, and across the world, it's now time because the kids are going back to school. What I'm going to do is tell you what you must know, what you must do when the kids go back to school, what you're going to need, what to look for. That's going to be important. Every child with a special education IEP needs to have those services written in the IEP in order for them to achieve an appropriate education. What happened in this case, even though they had those services in their IEP, the districts ignored those and sent them home. Then, interesting enough, the districts expected parents to provide the educational services that technically only licensed, professional, trained people were supposed to provide. So in essence, kids go home, do your own speech and language services, your own OT, and these types of services when you have no license or no training to do it. One of the most important things you've got to remember is that all of our kids are entitled to compensatory education, not just because they want to, because federal law requires it. So the governor, under SB 98, made it clear, even when he sent the kids to distance learning, that the state of California expects, and the law requires, that kids that have IEPs must have those services if the school districts go to a distance learning model. Now, this is why it's important, because the district, when they went to the distance learning model, they knew that they were supposed to provide services to kids with special needs, even though school was out. I mean, it's hard to think that someone could imagine something like COVID-19 would exist in the first place, but there were laws and regulation in place in case such a catastrophe happened. And even though the governor specifically said it was supposed to be done, the school districts kept it a secret, they ignored it, and they didn't provide it. When our law firm sued the governor and the school districts, the intent was they weren't following the federal law, they weren't providing the guidelines to the districts, and the school districts were playing a game of hide and seek with services. School districts actually are responsible, prior to letting the kids go out to distance learning, to assess them. Because now it was something different than their IEPs, so they should have assessed them to see that when they went home, they had the accommodations or services they needed. So let's look at the fact is, number one, they didn't inform parents that they were entitled to the services when school got out. Number two, when they sent them home, they didn't provide the assessments that they needed to provide the services when they got home. And then number three, SB 98 clearly says that should the students regress in any way, that they are entitled to compensatory education services, extra speech and language, extra tutoring to make up. Now, what they do typically with kids is that during the summer, there's no actual classes. Summer school is not as intensive. So what they do is they make sure that the students go to summer school and have these services because it's an interruption of the regular special education services. But what happened in this case is they're saying, if we document the IEP, and if we indicate that a student needs summer school, or even if we put summer school in their program, it's because over the summer, if they don't have the services, what will happen is they will regress, right? So tell me now, the kids have been out of school for a year, and the school districts are saying, we want to wait 4 more months to do an assessment to determine if they have actually regressed. What the heck are the school districts talking about? If they're going to regress during the summer and they're out of school for a whole year, we don't have to guess or do an assessment to see if they regress. Why would we make them wait 4 more months to obtain services to get them back on track? You know, there are 800,000 kids with special needs in California, but there are 7.3 million kids across our country with special needs. 200 million in the world. We're not going to be forgotten. This is a situation where they have to understand is that not only are the people who have kids with special needs affected, but there are typical people that understand and relate. Somebody's got a neighbor, somebody's got a kid, somebody's got a girlfriend or a kid or an uncle, an aunt, a neighbor. Somebody is aware of individuals that have disabilities. So we're talking about 20% of the world population. It's set on the side, and we're not going to provide what we know is supposed to be done, and then you go back to school, and we're not going to tell anybody that they're entitled to compensatory education to make up for the time they've missed. There's a lot to tell you about here. So now you understand that the school districts violated federal state law. Even in England and all over the world, there are laws that justify students and kids with special education to have these services provided to them, even compensatory services. It doesn't matter where you live in the world, there are situations and laws in place that allows the community to take care of those that struggle every day to do what most of us take for granted. So these particular school districts now have different rules and regulations. In London, if you do not send your child to school, you are fined £60 a day. That's a lot of money for every day your kid doesn't go to school, okay? I think that based on the fact that the school district violated the law here, didn't send kids home with the services they need, and the parents became the teachers, the specialist, the attendant, as well as everything else, I think school districts should be paying parents $60 a day for what they've been doing and teaching their kids for an entire school year. It gives you a little perspective. What makes this worse is that you think about collectively all of the money that the districts have been accumulating. The federal government has given them money. The state government has given them money. But it doesn't seem to trickle down to the kids with special needs. They had more conferences, they had more meetings, they had more lunches in big hotels, they're still traveling, but the money that was supposed to go to the kids with special needs didn't get it. And even the typical kids. I mean, typical kids have regressed after being out of school all year. The law says that they're supposed to receive compensatory education, but they're not getting it. So when the kids go back to school and our phones are ringing off the hook, it's because people are learning every single day what they're entitled to, what they're supposed to get. And I'll tell you right now, if you're going back to school and you think your kid's delayed, you better call an attorney. You better make sure the district understands that you're going to protect the rights of your child, because school districts aren't just providing those services and they're not being forthright.